To tell me more than 2 or 3 times.
Good morning, everyone. Oh, wait a minute. So you have something to say, don't
Yep. I figured that out too.
Yeah.
People here.
I'm gonna wait.
You're what I'm supposed to.
Good morning. I am Commissioner John Slutsky and God. My sisters, what's going on?
Yeah.
And this is a meeting of the Colorado Air Quality Control Commission. It is Friday, May 22nd, 2027, 6. And we are in the Sabin Blair Conference Room at the Colorado Department of Public Health and Environment. We have a quorum online and in the house, and that would include myself, Curtis Reeder, Dan Blankenship, Martha Rudolph, Jim Sewell, John Davis. Online, we have Jana Milford, Shelley Miller, and Greg Thomas. And with that, I think I can pass the call. Commissioner Blankenship to continue our hearing.
Thank you, Commissioner Slutsky. And as we left off yesterday, we had not closed the, what did we not close?
The record.
The record, thank you. We had not closed the record. And so we were at the point where we were asking the parties questions or not, but Commissioner Reeder, do you have some questions that you would like to ask the parties this morning?
I do indeed have.
Are they here to ask or?
So one of the parties is here, so
Okay.
I have a couple of questions for the division. Do you want to stay where you are, come up to the table? I'm not sure what the appropriate protocol
They
is.
probably need to speak into the microphone.
I have a question for John Putnam from EDF if he is on, so he can be prepped then to know that that's coming. So really two, I think relatively quick questions. First, I know you opposed some of the JWIG language around ERNs and making fees and everything, especially not wanting to put that in the rule. I guess I wanted to ask more about the SBAP and I guess more about how the division is thinking about it in terms of, is the division intending to try to build the 2028 calendar year emissions based on the 2027 ERNs, and it just doesn't want to be 100% committed to it in rural and SBAP, but the intent is to strive towards that. Is that the case?
Yeah, that is the case. That's very much our intention. We're just thinking it's going to kind of go in when we bring the other sources onto the ERN. And then we will know for sure that all of the programs are ready to be able to make that full consumption.
Okay, perfect. Thank you. And secondly, in doing some reading of Senate Bill 2204, there's some language, and I don't know where it appears in CRS. I like looking at the legislation, but it starts at kind of the bottom of page 14 and kind of 14, 15 that talks about in future fee adjustments, the division shall do some stakeholdering, but it also has some reporting aspects of that. And I want to ask about the reporting aspects. Where do those reports kind of go today?
So our reading of this particular provision is that we are required to report that information out to the legislature every year as a part of the SMART Act hearings, as well as through all of the materials we provide as part of the budget. We are more than happy if you are all interested in more of that information and would love any recommendations you have on what additional information you would like to hear. We would be happy to share that with you guys as well.
Okay. Thank you. That's all I had for the division.
While the division's up here, any other questions from any other commissioners for the division? Commissioner Slutsky?
Well, I'm more focused on fees because that's what runs the engine. And so my question is with the proposal that we have before us now and various amendments and the fees that would result from it, Does this maintain status quo for the division and the parties really, except for the huge outlay that they're being asked? Services will be the same. There's no layoffs, no reduction in pay. Any, will we notice anything?
So we don't anticipate any kind of layoffs. But what it probably will mean is that some of the positions that we might be trying to fill, or we're not going to be able to fill in this coming year. We'll probably have other requests that we need to make in terms of whether or not we need to pay the full amount of the indirect sources or whether we can get some forgiveness for that. So there are going to be some things there so that we can maintain all of the staff that we have hired and that we can kind of maintain that status quo. It definitely means that we will be somewhat limited in terms of what we can take on that's additional over the next year or so, especially as we try to kind of hopefully get some things more towards implementation anyway, and then we can move on into some next steps. But no reduction in force is the intention, but there may definitely be, as people leave, an opportunity to not refill those positions right away.
And wouldn't that affect services?
And
I mean, you
it would definitely affect services.
mentioned your old position not being filled. Who's doing that work?
Me and Emily Sanders is currently our kind of interim, but she's carrying a whole lot, trying to make that happen.
So if we were to go ahead and pass your proposal, this is going to add stress to an already stressed department.
Yes.
Thank you for your service.
Thank you for your question. Any other questions for the division? Anybody online?
I have a question.
Commissioner Miller, please ask.
Thank you. I had two questions along the lines of the conversation you were just having. If by some, if the air pollution in our state improves dramatically over the course of the next 10 years, let's say, will it be possible then to reduce the size of or is it in the idea that we then reduce the size of the workforce because we are needing to do as much regarding air pollution control? And this is a question that's more philosophical, I think, because when I was thinking about my role as an urban air pollution engineer, I thought, oh, good, with EVs and renewables, I'm going to be out of a job, which would be fantastic. But I don't want the. So my question is, yeah, you still have a huge level of work right now, and you're not filling positions, as you mentioned. But in the future, if we are accomplishing our air pollution control objectives and reducing emissions and the use of, what's going to happen with the air pollution control division?
So I think a great way to think about it is because we have to put rules and requirements into place to cause those reductions, those will still need to be enforced. And so some of these attentions may switch from a lot of planning and developing new rules and into compliance and enforcement. To the extent that there are natural changes or that, renewable energy picks up and we see a lot of that kind of start to naturally occur and it's not being driven specifically by regulation, there's a possibility in the long term that we are able to rethink exactly how we are structured. I think right now we see that as being fairly far away, but at the same time, that's our goal, right? Our goal is to get to the point where we aren't as necessary and that we possibly could, but I don't see that anytime in the future. And certainly I don't see that we would need to stop enforcing on the rules and requirements that we have established.
Yeah, thank you. Thank you for that. I also remember in the last time we talked about fees, I had asked what the comparison of the Colorado fees were to other state fees. And so I'd like to bring up that topic again so that it here is being mentioned in this hearing. So do you have, could you share with us a comparison of, say, the fees that you proposed to other state fees and where it might, are we on the high end? Are we on the low end? I remember last time I asked this, we were quite on the low end. So I wanted to know where we are currently.
Thank you for the question. This is Leah Martland. We do have a comparison table in the memorandum of notice near the bottom that provides some examples. It's not comprehensive and it hasn't been updated since we put that together for materials for the last April hearing. But I do want to note that it's hard to compare our fee program to other state fee programs because they're structured differently. So it really is just an example of what other emission fees are in other states, recognizing that other states have different fee structures for their permitting and source registrations. So in that round of fee comparison last April, we were looking to be on the low end, at least in comparison to some of the other states' emission fees. And now we are looking to be on the higher end in comparison. Again, but fee program to fee program is a difficult. We always say apples to apples and like grapes to cherries or something. It's hard to compare because they all set up a little differently.
Thank you. I have no further questions. Appreciate it.
Thank you, Commissioner Miller. Commissioner Thomas or Commissioner Milford, any questions this morning for the staff or anyone else? Yes. Okay. Commissioner Sewell, please.
Yeah, I'm gonna sound like a broken record again, but the permit timelines and the backlog, is there any benefit to the division to reduce that backlog at this point, like in costs or future fees? I mean, I can think of a few, but maybe I'm mistaken, but.
I think to us, what we are striving towards is to be able to provide that service more quickly, to get into compliance as best we can with statutory timelines. Again, this is a system that has been behind for so long and it keeps kind of having things piled on top of it, that it has been hard to even catch up, let alone deal with the new. But I think that is absolutely our goal. So I think we're focused more right now on getting ahead of that. The concern what has happened historically in state government and kind of all government is that you say, okay, well, we've gotten ahead of it. We're at a steady state. We could cut back staff and then there's a boom. And then we have a flood of applications and then we're kind of back where we started. So I think we'll have to evaluate that at that point in time once we kind of get ahead of it. So if there are opportunities, I think that we will take them to cut those costs to the extent that we can.
Would it help if the backlog disappeared next year or two, or got it down to a manageable number? I mean, do your legal costs go down? Do your administrative costs go down? Do your just
Not
general
necessarily,
staff costs?
because our staff costs are the bulk of what we do. And I would also just suggest that we are also much more likely in more recent years to get sued on permit actions and to receive a lot of petitions, which has driven up some of those costs that we maybe historically hadn't had to account for. And so it's hard to know exactly where that would go in the future, to know whether that kind of litigation would be continuing, in which case we would not really be able to cut back on a lot of the costs that would just kind of transfer into defense of various permit actions. It's not an easy thing to acknowledge, but I appreciate you.
From my view, I mean, I would think just administrative costs would go down where you're not going back and forth on extension letters or something like that. Legal costs obviously would, could go down.
I think on a per permit basis, that's probably true. I think when I think of costs, I'm thinking of total costs across the division. On a per permit basis, I think that could definitely be true.
Then I would think, well, the longer you're waiting on a permit, things change. It's for an operator. So then you're redoing work and that creates work for the operator, but also the division also, to start over again, you know.
Absolutely.
Yeah. So anyways. Thank you.
Oh, we have Commissioner Thomas. You are on mute, Commissioner Thomas. Nice facial expression, Commissioner Thomas.
Yeah. Stephanie, are you able to share any insights into the conversations you had with, I don't know, I'll call it the Joint Budget Committee, but the legislature, knowing that their desire is for the division to be able to cover its costs through fees? I'm guessing a lot of this early information regarding significant fee increases was discussed as part of your budget conversations. Are you able to share anything from that? I mean, I would assume that they knew that the fees are gonna have to go up a fair amount, so I'm just kind of looking to gain insight from, their reaction to that.
Yeah, there definitely were conversations kind of throughout that process. And the most kind of recent time that we requested additional general fund to help support the division, I think we heard very, very clearly from the JBC that they did not, that we should not come back to them again for general fund, and that we should raise our fees in accordance with what we needed. And so, yes, I think that instruction came in that conversation.
Okay, good enough. Thank you.
Any other questions? Hearing none, then is it appropriate now that I ask for a motion to close? Oh, we have another one?
I still want to ask a question. Yeah, I didn't know if you were saying any.
Okay, no, I'm sorry. I'm sorry, Commissioner Reader. That is correct. You did make that request. So please go ahead. Thank you. And so go ahead with your question for the EDF.
Okay, I see Mr. Putnam on screen. So thank you for your testimony yesterday about the origins of SB 2204. I found that very helpful and enlightening. I had one follow-up question. I was just curious if you're aware of any other arrangement in the state of Colorado that is similar to
Commissioner, I missed you after 2. Looks like Commissioner Thomas also has lost sound.
It went quiet in there.
Yeah.
I think we should be back on this.
Can you hear us now? Are we back online?
Yes, I thought you were taking an exceptionally dramatic pause. So
Just a minor technical problem on this end. I appreciate your testimony yesterday about the origins of Senate Bill 2204. I found that very helpful. I was curious if you were aware of any other example in sort of Colorado government where there's a similar arrangement to what we have here, where the legislature or the General Assembly, approves the budget, but the commission or the board is sort of tasked with adjusting fees for revenue. It seems like I would just be editorializing. Say anything else, I'll just stop there. Are you aware of any other example in the state that works quite like this?
Thank you, Commissioner. I believe some of the fees that were created for CDOT at about the same time, I think the session afterwards in Senate Bill 21260, that also went to some of the enterprises within CDPHE Energy Office and CDOT, as well as some that went into the highway fund, also have appropriations requirements associated with them. But I also believe, but don't have at the tip of my tongues exactly what those fee setting provisions were. Often they are more extensive than what I would see here in terms of process and other sort of pieces. And there was a little bit of process that I think you had the question for the division about this morning in terms of the annual report and starting a stakeholder process 6 months ahead of time. But there's not a lot here.
So you're saying those other instances maybe have a lot more process associated with them? Is that?
That's my recollection, but it's
Okay.
been a while since I've looked at those specifics.
Sure, understandable. Okay, thank you very much. I appreciate that.
Thank you.
Any other questions, commissioners, for any of the parties? Okay. I think that it's appropriate now to ask for a motion to close the rulemaking record and enter into deliberations.
So moved.
Second.
We have a motion and a second to close the rulemaking record and enter into deliberations. All those in favor signify by saying aye or raise your hand. Aye. Opposed? That passes. And so now we may begin deliberations, and I would like to begin the deliberation process, I would like to make a statement or read a statement. As we saw in the filings and the parties' presentations, the topic of fees brings up strong feelings. The magnitude of the proposed fee increases has pushed us into new territory in which we now scrutinize the commission's role. We have heard multiple opinions on what the statute reads or implies about the commission's role in setting fees. But one of our roles as a commission is to provide a forum for the public and for the parties to share their thoughts and feedback on the work of the division and the commission, including concerns we've heard regarding fees collected by the division to fund its work. But it's important to distinguish that the responsibility to hear concerns from the authority to act upon them. They're not one and the same. The commission was formed by the General Assembly, and the commission takes direction from the General Assembly via legislation. The commission has no authority other than that granted by the General Assembly through the passage of legislation, which is signed into law by the governor. Specific to this hearing, the General Assembly has not directed the commission to take its place, nor any other role in the budget process. And that is establishing the spending authority when I refer to budget process. To maintain the integrity of the process, we must and will honor our purpose and direction. I do not believe that we have the authority to second guess the legislature when it comes to making judgment calls about what programs to fund or in determining the appropriation necessary to fund those programs. The most appropriate time to express objections to the division's budget or spending is during the General Assembly's budget process. Until directed otherwise by the General Assembly, the commission is not and will not be part of that budget process. We have the ability to review the distribution of fees that allocate the division's direct and indirect costs associated with implementation of the AIR program. We need to consider whether the proposed balancing of those emissions fees, processing fees, and APIN filing fees are appropriate. One question that I would like the commission to consider, given that it is our statutory obligation to set fees, and I quote the statute here, in an amount that is sufficient to cover the indirect and direct costs required to develop and administer the programs established pursuant to this Article 7, by taking action to approve fees that will not be sufficient to cover the indirect and direct costs, and that's the amount that was appropriated by the General Assembly, are we meeting our statutory obligation? I look forward to hearing from my fellow commissioners and thank the parties for your participation in this important process. And with that, I will open it up to comments by any of the commissioners. Commissioner Reader.
I'll just start by saying thanks to all the parties, to the division and all the parties for all their hard work through this process. I know every rulemaking we do has its own twists and turns and work, and appreciate all the work that everyone's done. To bring us really a proposal that there's relatively little dissent about. I'm supportive of the division's proposal with all of their various little tweaks they had of the update language on all those various slides that they referenced yesterday. I do have a couple of very minor tweaks to the SBAP language in a couple of places that I would like to discuss during deliberations. I continue to be, I'm troubled, it's not quite the right word, but I'll use it in the absence of coming up with a better word, by this what I view as a fairly unusual arrangement that the General Assembly has created here. When I think of other boards and such that I serve on where I approve revenue estimates, I also have some oversight over the spending side and some input on that. I think it's a very interesting bifurcation of responsibilities that the General Assembly has created here. And it'd be my personal preference that they would change it and either give us all of it or take it all back. I'm not a fan of this particular arrangement. Having said that, I also recognize that's the General Assembly's decision and not my decision. So I will honor the existing arrangement and support the division's proposal. From a very minor editorial point, I heard some testimony that bothered me a little bit about regulated entities and their ability to pay and everything else. And I simply wanted to be clear that as a commissioner, I feel like it is my obligation to look at rules that protect and improve air quality in Colorado and that are technically feasible and cost effective. And technically feasible includes, both if technology is being used, does it work? And is the language clear and implementable? Other things like the ability of regulated sources to pay or not pay are not germane to my decision making. And so I don't especially think those comments are that relevant to our proceedings. And with that, I think I've said my piece.
Thank you. We have Commissioner Milford. Please proceed.
Yeah, I'd like to thank all of the parties and the division and our staff for their hard work on this. Commissioner Blankenship, thank you for your work as a hearing officer. And I appreciate the comments that you just provided. I also agree that we don't have the authority to really second guess the governor and legislature and JVC process in terms of the top line. I think the value of this process and the ability to allocate between different fee categories came through in this rulemaking process as the division made a very substantial change to their original proposal in adjusting the balance between the emissions reporting notice fees or filing fees and the permitting hourly fee. So there's strong value in the parties' participation in the allocation step that has been assigned to us, and I think the process has worked well. I would support the division's proposal, but I do have one small request, an adjustment to the SBAP. It hasn't received a lot of attention in this rulemaking, but I think the striking of the annual information reporting requirement on the oil and gas activities. I'm comfortable with omitting that from the regulatory language, but I would like to ask the commission to adopt the SBAP language that the division prepared for us, hopefully, yesterday. I think that information about annual emissions trends and LDAR reports and the greenhouse gas intensity progress, all of that information is really important to the public. And I think including that language in the SBAP will help us ensure that that is available going forward. So I'll ask for that minor amendment to include the language it was on page 12 of the division's rebuttal testimony. So thank you.
Thank you, Commissioner Milford. Commissioner Sewell?
Yeah, I'd like to thank the division also for all the information, great information. I love your presentation with all the photographs. Made he's a little more able to stomach, I guess, the review of that. But so much appreciated. I do support what's proposed here. I do also believe there should be more process. Transparency, I guess, is another word for that too, on the process for next year. How we get there, I'm not sure what information to put out there. I'm not sure either, but I think, we do air division updates. We could do like any other organization or business. They do a financial report, feedback on where we stand on fees, what's coming in and what's going out as far as expenses. So I think that could be handled in our course of business for the next year, because I'm sure we're going to be talking about this next year too, and a fee increase. I also believe it's reasonable to have some metrics around where we are on the permit backlog. I do believe that costs the division money, whether or not it's legal fees or just time of staff and things like that. So I've, worked that backlog down. I mean, I don't see any way of doing it other than putting staff to that process, which could be more fees, but it would be good to see where we are on that. Is it improving with the measures you're putting in place, as well as tying it to a fee structure this time or next year too. So again, I support what you're doing, appreciate the information and how it was provided. Thank you.
Thank you, Commissioner Sewell. Commissioner Schletsky?
Well, I too would like to thank the division's representatives here and presentations. I also would like to at least acknowledge the parties that presented in general, that present to us month after month. We have a great air division, and I think that some of their greatness may come from their interactions with our parties, who are always so polite and well thought out and present really as well as the division does. I think they don't get that love from us that maybe we should. But I'm supporting the division's final proposal as amended in their rebuttal presentation, including slide 10, which is the removal, the addition of section 10A5B and 10A5, the latter which would remove the former when EPA does their job. As I said, I'm more focused on the fees. And the question of the fees being taxes that we belabored for so long yesterday, for me, was just a distraction, as was, to be honest, some of the rest of the hearing. question of us interpreting Tabor, that's just silly. That would take a bigger hearing. We heard we need more transparency, and who could argue that? We always want to see it all. Commissioner Miller asked, "What does that mean?" And that's I didn't say that yesterday, but it was like, yeah, what does that mean? What should we be expected to go through the division's books? We can all probably read a P&L sheet, balance sheet, P&L statement. Is that really where this commission is expected to go? Does that even provide us with information to decide whether those expenditures are necessary and or required? I don't see how we could be expected to do this. I do understand how the regulated community can't accept your proposed, the division's proposed fee increases without even protesting. We've been getting so much help from the state and the feds in the past, and now we have to fund those programs with fees or alternate funding, which really no one even tried to describe. This must have been kind of a shock for our parties once they digested it, and I get that. We have been subsidized for years, and now we're seemingly on our own. This is a huge step. We demand transparency, efficiency, accountability, but I think we already have those things by some measure. We should make improvements, sure, where we can and when possible, but is it possible to do so if we demand cost savings at the same time we are figuring out how to go this alone without funding from the legislature or the feds? This is new territory, and we have to keep our programs going uncompromised. And I'm sorry, and with no disrespect, but the oddest idea I heard yesterday was to issue permits in 90 days, even if we have to skimp on the details. How do we even do that? We don't dot the i's, but we cross the t's, and then it goes to the EPA if it's a Title V permit, and they're looking at it and go, geez, they didn't cross the t's. And then they send us back the permits, and we have to start over, and there's more charges for our parties, our industry. I just don't understand that mindset. And then we heard public comment that emitters should pay for reducing pollution that they contribute to, and that the public's already paying for this with health effects, and they suffer from those emissions. We have a duty to improve and public health and the environment. So I'm voting to support the division's proposal and not on skipping.
Thank you, Commissioner Slutsky. Anyone else that would like to, Commissioner Rudolph?
Thank you. I always like hearing what my fellow commissioners are thinking, because it does help me sort of gather my thoughts, because as anyone knows, I sort of think out loud and sometimes it's a little scattered. So I am voting for the division's proposal. I agree that with our fellow commissioners, and my understanding that we don't have the authority to set the actual budget, that is in the hands of the legislature, working with the governor's office. Certainly the division provides information on what it believes the costs will be and the revenue that it needs. But ultimately it is the legislature that decides that. So I think that is not something that we can do. I understand the desire for transparency by the fee payers and the public in general. That has for a very long time been an issue. And what I was hearing yesterday and trying to understand what more information is needed that has not been provided, I did not get a good answer. I did not hear, well, the division has failed to provide us with these details. It was, I don't really know what more we need. I think that's a problem. And Mr. Putnam, I think, said it correctly when he said, find us another rock. I think my view is the division tries very hard to provide as much information as they can and that they have. And when they're asked in the form that may be asked, in the detail that may be asked, I don't see the division hiding the ball here. But they need to know what kind of ball they want, and that hasn't happened. I do think the issue is the permit backlog. I think ultimately that's really what the issue is. I agree that statistics should be given, but what I also heard yesterday from the division is that there is a dashboard. And I presume this dashboard is something that is public, that talks about, here's where we are with the permitting process. Permitting has long been a problem. Perhaps a way to solve it would be to allow the division to reopen any permit at any time if they find that there's an error on the division's part for something they didn't put in it. But unfortunately, that's not what is allowed. These permits, when they go out, they are solid until the laws change, or 5 years or whatever, however long the permit term is. So that's part of the issue, is to make sure that what's in the permit is right, because the division rarely has an opportunity to reopen a permit once it's issued. So I want to say, as far as the statement of basis and purpose goes, I would be fine with the proposals that's been proposed on page, Jana, it's on page 11, and then on 10, I think was the other issue? Slide 10 of the rebuttal. I'm fine with those two languages. Or suggestions. I'll be interested to hear what Commissioner Reeder is interested in. And yes. And I appreciate the comments on that Commissioner Slutsky said about the Tabor issue. This is a rule, in my view, that for the most part greatly benefits the fee payers. They're getting something from the fee that they're paying, and the fact that there's a secondary benefit is great. I mean, that's the whole purpose of the AIR program, is to provide benefits to the public and the health of the public at large. From my perspective, that is irrelevant for purposes of Tabor. So I have no issue there. And other than that, I think those are my comments for the moment. I'm sure as other commissioners speak, I may have more to say. But I also want to thank the division. I think you did a tremendous job with this. You came up with some compromises. You worked with the fee payers and with the parties to come up with a proposal here. You made modifications for your final proposal, which addressed some of the concerns that were also raised by some of the parties. And I think the parties did a good job. I think that this was a really good rulemaking. I know this takes a lot of work, and it's, as was stated, it's a big surprise potentially, but probably not a great surprise that the fees went up as much as they did. Given that we know where we've been, we know where the money's been cut from the feds. General fund is never something that you can rely on for the air program. It's always a surprise when you get it. It's really nice, but it's can't rely on it. So I think that people knew that this was coming and worked really hard to make it work. So I appreciate all the effort that went into it. So with that, I will stop.
Thank you. Commissioner Miller.
Thank you. Yeah, I wanted to really thank all the parties for their presentations and their participation. It was really informative. I particularly wanted to give a shout out to the local government coalition. I really appreciated hearing from them and from their reflection of their constituents. I also agree that it's not clear what as I said before, what the transparency issue is. Because we hear from the division that most of the costs are personnel time. So then if we have to sort through the time for the personnel spent on doing the work that's required to allow the industry to emit pollutants into our environment, then it's a matter of, it just doesn't make any sense to me to have more transparency and understanding the personnel time. And I think we actually need higher fees to get the backlog of the permits done. We need to hire more people to get that done. So the conflict for me is we're complaining about the transparency, the fees are too high, and yet also there's a backlog. And so I think we're getting there in terms of how to address these problems. And this is my first rulemaking or hearing on this kind of topic, but I'm still struggling with the incongruencies. With that said, I would like to make, I support the proposal, but I do have an amendment that I would like to propose. I would like to propose that we retain section XA5 as currently written. While the division states that removing this section XA5 would better align with the PSD program with federal requirements, this additional state level provision, we could clarify that state level, provides a more protective framework that has been successfully implemented without conflicting with federal standards. And we don't have that many requests for this work. Retaining this section preserves this additional safeguard and ensures continued protection of air quality increments without undermining the consistency of the overall program. Maintaining this provision does not impair implementation of the remaining increment provisions in regulation number 3 and supports a more precautionary approach aligned with Colorado's air quality goals and frankly, the constituents of our state. That's all I have for now. Thanks.
Thank you, Commissioner Miller. Can I ask a question on the section that Commissioner Miller has requested that we retain? Is that part of the staff's proposal was to retain or to eliminate that?
It's on their site.
Oh, go ahead. Somebody more informed about it. My understanding was they wanted to remove that part because they wanted to improve efficiencies to and I don't want them to remove it.
Okay, thank you for that clarification. Commissioner Thomas?
Thank you. Yeah, I do also want to thank all of the parties for the relatively low amount of disagreement that started out this hearing. I thought that it made the rulemaking go a lot smoother. For myself in future rulemakings, I would like to better understand the full breakdown and the trends of the direct and indirect costs, so as to better understand what cost categories are increasing beyond normal inflation. At a high level, that would be salaries, fringe, contractual services, capital equipment, and any transfers that happen. I don't know that requires any SBAP language, but it is something I would hope that future commission keys in on. when the next fee rulemaking occurs next year, I would like to see a more recent analysis of Colorado air fees versus other states. The various fee increases that the division has proposed, while significant, are not out of line with other CDPHE programs, like in the Hazardous Waste and Materials Division. I'm encouraged by the development of the performance dashboards. I agree that reducing permit wait times would be the single best accomplishment that APCD could make. There are a lot of new programs within the APCD, as we've heard. And while very few find permitting to be exciting, reducing the time to approval would be a huge accomplishment. I will support the division's proposed fee increases, but at this pace, the questions from fee payers and the commission will only get harder as fees are projected to grow another 30% by fiscal year 2030. Thank you.
Thank you, Commissioner Thomas. Question for our attorney and staff. Would it be appropriate, since we have a Commissioner Miller, who is suggesting or requesting that we retain a section that the staff had recommended that we remove? Would it be appropriate to ask the staff to address that? Is that acceptable?
In what way would you like us to address it?
Maybe to understand, now that they've heard Commissioner Miller's reasons for keeping it, if they have any concerns with that, or to maybe elaborate on why they were recommending it be removed.
Can I make a statement?
Please.
I asked a number of times for clarification on this point, and I got a number of answers which weren't enough for me to admit that I want this removed. So I think that you asking them again to give me the same answers is not going to be helpful. I brought this up for discussion amongst the commission.
Okay, I don't feel that I don't feel myself that I could make a determination one way or another.
You could entertain a motion to reopen the record and see if other commissioners agree with you.
Is there any interest in hearing more from staff on this, or does everybody feel like that they have enough information to make a determination?
Good.
Yeah, I'm good.
Good. I'm getting a general consensus that we're good, so we'll proceed with that. Thank you for responding to that question.
We're proceeding with what? I'm sorry, I didn't understand.
Oh, I'm
You
sorry.
guys are whispering over there.
No, I'm sorry. Yeah, you were, I have my back to you. I asked the commission if there was any interest in hearing further clarification from staff, or if they felt that they had enough information to make a determination on Commissioner Miller's request. And the general consensus is that they all have enough information to be able to make an appropriate determination. Are you okay with that?
Personally, yeah, but I would say with respect to Commissioner Miller, I would not be opposed to letting them clarify this.
Yeah, and I don't think she's not asking for that. I was the one who was.
I got no respect for you, so no.
Okay, there we go. Perfect.
Commissioner Blankenship?
Thank you.
Commissioner Milford has her.
Yeah, Commissioner Milford, please.
I was just going to suggest that maybe we could pull up the language at issue and at least have that in front of us, and then give Commissioner Miller a chance to speak to what she's proposing. And I hope we can do the same thing for the SBAP language changes that Commissioner Reeder and I have recommended.
Slide 10. Of the rebuttal. Slide 10 of the rebuttal.
So we have this language up here on the screen. Commissioner Miller, are you suggesting that this language stays or goes?
Is this different than their direct presentation? This is the rebuttal, so it's not the complete change that they proposed. Maybe we could look at the direct first.
Commissioner Miller,
Yes.
to accomplish this in my understanding, the legally supportable way, we wouldn't be able to use any of the division's language. We would have to do something different. Corey and I have been working up the language for what it is we understand you're proposing, which is that upon EPA action to remove it from the SIP, which is not something we have control over, it would remain state only. It would remain in the regulation as a state only provision.
Yes.
So, yes, so that is different than what the division has proposed in substance, and so would require slightly different language. And so we have written that up. So if you want to talk about the merits, and then we can put that on screen so you would see what it would look like, but it would essentially be to add a parenthetical after the title of the subsection that says upon effective date of EPA action to remove this from the SIP, this, state only upon effective date of EPA action, right? So clarifying that once EPA corrects the error that the division has advised EPA has told it intends to do, it will not be in the SIP, but it will remain state only in the regulation, which is what I understand you are asking for.
That's what I'm asking for. Yeah, I would like to see it remain as state only, and I've mentioned that a couple of times. And thank you for that proposal.
Yes, thank you for that clarification and for drafting some language for the commission to consider. Anything else?
Just to quickly pull up the language in the final rule proposal. This is what it looks like now. What you were seeing earlier was the suggested edits by the division. However, if we were to do what Robin just said, it would be this section, retaining it and putting in that parenthetical at the top.
Yeah, so essentially the division's rebuttal proposal was correct because of the quirk about how and when this would become effective and when it would no longer apply to deal with pending permit applications. So what it would look like is all of this stricken language would come back. And then after the subheading, 10A5 increment consumption restriction, there'd be a parenthetical that would say state only upon the effective date of EPA final action to remove it from the SIP, basically.
Okay, thank you.
Yeah, that meets the concerns that I have. Thank you.
Okay. I'd like to make another statement. The first statement I made, I was kind of with the hearing officer hat on. I'd like to just make a statement more of my view as a commissioner. And
Can I interrupt a sec? Because I think Jana had requested that we do something first about the SBAP, and then you could do your statement, just to follow up on all the amendments.
I'm sorry. I was concentrating on my statement. What's the request?
Well, there were two requests. One was to look at my friendly amendment, and the other was to look at what Commissioner Milford had proposed. We did look at what I proposed, but we did not look at what Commissioner Milford proposed. So if we could do that, and then you could do your statement, that would be great.
Yeah, I was planning on addressing that, but if
sorry, I just want to keep with the amendments.
I'm fine if you want to go ahead with your statement. I just want to make sure that the commissioners who have interest in changing SBAP language have an opportunity to have that addressed.
Absolutely. Yep. That's my plan to address after all the commissioners, including myself, have had an opportunity to make statements.
Good.
Okay, I'll continue. As an individual commissioner, I'm a strong advocate for us staying within our lane. And again, our lane is established by the General Assembly. And in this matter, I believe that our lane is narrow. I also acknowledge that coming to a common understanding of that lane width is utmost importance in moving forward. So maybe that's a topic for our retreat, is our statutory authorities. I'm neither a fan of runaway government nor the spending associated with runaway government. However, over time, and most recently, like it or not, our state has passed several laws that are intended to improve our air quality. We have some of the most rigorous air quality laws in the nation, and that comes at a price that, according to the General Assembly, will be paid for by the fee payers. Those laws have resulted in very significant increase in workload for the APCD, which they must undertake. It's a mandate. The General Assembly has taken action to establish the funding level for the Stationary Sources Program, including the direct and indirect costs. That's the budgeted expenses. If we don't establish fees to cover the budgeted expenses, we put the APCD into a conundrum. The APCD has been tasked by rules from this commission, legislation, executive directors, directives through the chain of command, and EPA regulations that are necessary to implement the AIR program, including the Stationary Sources Program. On the other hand, the state constitution prohibits spending in excess of available revenue. Simply stated, you can't spend what you don't have. If the division is underfunded, which of these mandates do they not comply with? That's the conundrum. All that said, I strongly support continued focus on process improvements and efficiencies, specifically compliance with permit processing times, but that it's the function of the APCD and CDPHE administration. We can encourage and or request, but I don't believe that we can mandate or direct the operations of the division. Based on and I think this is important, based on the information presented in the record, I believe that the proposed fees represent a reasonable allocation. For the commission, but going forward, for the commission to appropriately discharge our duty in allocating costs amongst fee payer categories, I believe that a detailed cost of service analysis that includes the specific calculations and supporting assumptions and methodology describing how the costs are allocated and fees established would be most helpful in providing additional transparency. But once again, that's for the administration to determine if that is an appropriate approach. I posed that question to the individuals that were representing the utilities yesterday. They were not familiar with that. They were not able to answer your questions about what should be included. But I do know that the individuals in the utilities that are associated with setting fees and rates are very, very familiar with what a cost of service study looks like. And a simple does not, because of the way that the division is set up, it's not as complex as utility rates. So I think it's something that can be done simply and can be a document that provides the transparency that everybody has been talking about, but has not been able to define. Furthermore, I believe it would be beneficial for the commission to receive the report required by CRS 257-114.7, Roman numeral 4, and that's the section that Commissioner Reeder was referencing earlier from the bill, no later than when a fee setting rulemaking is requested. Again, because we can't direct the operations of the division, please accept this as a request. So that request would be for that report that I think Stephanie indicated is provided to the legislature would be provided to us either at the time of a request for fee setting rulemaking or before that. So as I indicated previously, based on the information presented in the record, I believe the proposed fees represent a reasonable allocation, and I will be voting in favor of that. Now, I would like to address the proposed changes to language in the SBAP and or other modifications to the staff recommendation. I know that our staff here listens diligently to what's being said, and typically we'll prepare a list of items that have been mentioned.
We have a list.
You have a list. I suspected you might. Would you like to share that list in some form or manner so that the commission could then, we can either, whatever the commission's pleasure, we can take them one by one, or we can take them as a whole, or we can have a discussion, whatever the commission's pleasure is.
I get,
Go ahead.
I'm not sure what the divisions list is. My suggestion is we should simply deal with Commissioner Miller's request, Commissioner Wilford's request, and my request, and we can just go through those in any order. I don't care.
Okay.
But I think we discussed those three, and then I think we will be at consensus.
Okay.
Our list has Commissioner Miller's request, Commissioner Wilford's request. Then we have broken out, Commissioner Reader, your request on the SVEB language on ERNs as one thing, and then the language that both you and Commissioner Thomas indicated you are interested in around the reporting and more information on fees. So our list has 4 things, but yes.
Same thing. Okay, perfect.
Okay.
Okay, as suggested by Commissioner Reader, if you can maybe put the list up on the screen, and we can we'll just go down one by one and see if any of the individual commissioners have any
We
comments.
just need a minute.
Okay, why don't we take say a 6-minute break and come back at 9:45.
That's 6.5.
No, enough with suggestions.
Take home, just
Okay, welcome back. Staff has informed me that they have prepared a list of the items that we're going to consider. And so if you can put that on the screen for us.
And we have a separate Google document with the SBAC language once we get to Commissioner Reader's and SBAC language. This is the list, and then when we get to sort of bullet 2 and 3, we have a separate document too.
Okay. We'll just go bullet by bullet. Is there any comments or discussion on the division's rebuttal testimony, slide 12?
That's the language Commissioner Milford was referring to.
Commissioner Milford's.
Yeah, so is it possible to pull up that language?
Yes.
Yeah, thank you. This is it. So the division was proposing to delete section VD from the annual report. This was a requirement that the division provide a report to the commission and the public that summarized a lot of oil and gas data. And I am supportive of removing it from the regulation, but recognizing that there is a tremendous public interest in this information, I want to make sure that it continues to be provided in the way that the division currently says they're providing it, which is through the website, through briefings to the commission, and as well through the ECMC annual report. I would just note that this issue was raised in an extensive public comment letter that came from Earth Justice and a number of other groups that they were representing. So there was a very specific request that we pay attention to this information that came from the public comment. So I think it's not an additional burden on the division. I think this is stuff that they're already doing, but this would just be a statement of our expectation that that will continue. So respectfully request my fellow commissioners to support including this change to the language in our package.
Thank you, Commissioner Milford. Is there any comment, question, or objection or concern with Commissioner Milford's request?
Okay. I would, in years past, I hate to be the old guy, for more reasons than just one. The SBAP was a document that we used to give our mindset and what we expect for future commissions and division staff to do. And that's what this is. This is not anything more than our bent, what we want, and without making a directive or anything that we're so asked to do these days. This is just where we stand, and it's historical, and I think this is the way we should proceed in the future as well.
So it's kind of like a commentary.
Yeah, but it's more historical.
Right.
Because we already know this stuff.
Yeah.
This isn't for us.
Very good. Okay. Hearing no concerns or objections with that, we'll include that with our motion. Next item, please. Next item is the JWIG SBAB language on ERN's direct presentation, slides 7 and 8. Is there, which commissioner wanted to address that?
7 and 8. Yeah.
Commissioner Miller, please.
Yeah, I just wanted to add that my concern over this PSD increment comment does come from reviewing some of the public comment. And so that was, because I heard that Commissioner Milford pointed that out as well. And that is also something that I took into consideration when I was considering this particular part of the regulation.
Commissioner Reader, did you not want to look at these slides? You just wanted to look at what you said?
I just wanted to look at my SBAP language.
Just that, sorry.
Is that tab 1? So just this first change, right?
So where is that?
So this is on page 29 of the SBAP. And all I did was, my proposal was simply to add the sentence at the end, which I asked the commission about this morning, that they hope to do that. And so I'm
The
simply
division, you mean?
asked the division, sorry, yeah. And that they hope to do that. So I simply sort of memorialized that. So the last sentence, now the commission intends for the division to assess ERN filing fees, as well as future annual emission fees on emission points, and emissions that were paid and reportable, and to strive to begin billing on ERN fees in calendar year 28 for 2027 emissions if practical. So simply expressing in a sense, memorializing what the division said they were going to do, as well as expressing some intention from the commission that it would be nice for that to happen.
Thank you, Commissioner Reader. Is there anyone who has any concerns or objections with the proposal by Commissioner Reader? Hearing and seeing none, we will include that with our motion. Next item, please.
Just scroll down to the other language. So the following language represents our effort to capture the comments from Commissioners Thomas and Reader regarding what does more transparency and more information look like, especially with the reference that the commissioners made to the reporting that the division gives the legislature under 25.7.114.7. Obviously, this is just our attempt to capture what we heard you saying, and so please direct as many edits as you would like.
So Commissioner Thomas or Commissioner Reader, would you like to address this, please?
I guess I would say it's relatively self-explanatory. This is the part from SB 2204 that I asked about this morning that they said is largely recorded under the SMART Act. Commissioner Thomas had similar comments and actually sent an email to Robin already about asking that be in. And actually, I heard Commissioner Blankenship in his reflections also sort of asking for, I think, essentially this information from this statute. So it's simply adding that to the SBAP and asking that they provide information. And I said information. I did add the word similar, I think, in what I'm not sure if that's exact, if we exactly want to see the SMART Act information or not. I'm not sure what that volume is. So that's why I put the word similar, just because I'm not quite sure, not knowing what it looks like. I don't know if we really want all of it, but some information similar or comparable to seem to make sense to me. And then actually the last part of that, the salaries, fringe, et cetera, is all from Commissioner Thomas's email that he sent to Robin. So Commissioner Thomas, feel free to chime in.
Yeah, I think we heard this from the JWIG, we heard this from the Western local governments. And it just comes down to transparency. My intention is not to add work through the SBAP to the division's plate. And so I like what's here in terms of similar to, or maybe it even 25, the reference there satisfies my questions in terms of we just got to understand a little bit more beyond just the high level program number. Because I think folks are going to be interested in seeing okay, where is there potential wiggle room or flexibility? And so hopefully this is not a huge lift for the division, but I like what's there.
Commissioner Milford has her hands up, and then I'll come to you. Commissioner Milford, please.
Yeah, I appreciate the sentiment here. I wonder if it would be a friendly amendment just to delete the parenthetical at the end. It seems like that's just a little step too far to be too prescriptive.
I'm okay with that.
Yeah, I'm
Personally,
okay with
that too, but maybe it goes a little bit too detailed.
Thank you, Commissioner Milford. Commissioner Rudolph?
I have a question for Commissioner Thomas. When you say that it may provide some flexibility for what?
I don't, maybe flexibility isn't the right word, Commissioner Rudolph, but really just more granular detail in terms of, you know, I suspect that personnel cost and related, fringe are the big driver. We heard that, I think, from Ms. Shout. So I just think it's the natural evolution. We kind of discussed this last year when the fees were increased as well, but didn't really see that additional detail. And I have to believe it exists, whether it's in the budgeting programs that the division uses or in the report to the legislature. So um, that's really it. But it could be an example of, oh, air toxics program needs $10 million next year for new monitoring. I know that's not on the table, but it would at least allow them to say, could that wait another year and defray some of the the cost increases for the next rulemaking. So I guess that's where I'm coming from on that.
So I guess my concern, I can understand the commission's curiosity in wanting to have this information before it. But I don't see that the commission has any authority to change it. In other words, this is information that goes into the top line budget. And since I don't believe we have the authority to say, nah, that's too much for this program, let's move it to that program. Those are budgetary spending authority decisions from the legislature. I think it's fine for us to have better information on what are the costs, just to have it out there for the public to see, for the fee payers who already hopefully see this, and for us to have this information. But I don't want to give the impression that we would have the ability to change it in any way, because I don't think we do. And so maybe having a language in there that indicates that it is just really for information only. I don't know how quite to put that, but I don't want to give the impression that we have the ability to affect what these costs are.
Yes, understood. And, but that information could be used by fee payers or their representatives at the next, in the next legislative session. It could be a point of discussion with the division itself in terms of if this, then that, and that would affect the fees that are being brought to the table. Again, I started out my comments by saying, I'm not a huge fan of bulking out the SBAP. And I don't want to, put in things that'll direct work. So that's something I'm going to pay attention to when the next fee setting happens. Whether it's in the SBAP or not, doesn't really matter to me. It just, so I don't know. I can't speak for Commissioner Reeder, but for myself, just a little more depth in understanding what goes into the fees, even if we can't say, well, you need to change this budget. We can't do that. I get that, but.
And I appreciate that. And Robin has added some language that I would be fine with for purposes of transparency. That I think addresses my concern. I don't know if it for everyone else. Thank you.
Commissioner Reeder?
I would simply add, I don't think any of that language that's up there right now, with or without for purposes of transparency, implies that we are, I mean, we're simply requesting that the division provide information. So, I guess if we wanted to have that phrase in, I would say as part of its annual report on fees to the commission, and delete that comma, and for purposes of transparency, so it's all part of that kind of one phrase. Because I think otherwise it gets really wonky from an English perspective.
Yeah.
I love a comma. Fine taking it out.
Any other commissioners, any
Commissioner
comments?
Blankenship?
Yes, go ahead, Commissioner Milford.
Sorry to speak out, but I wondered if we could just delete the first 5 words in furtherance of that work. That's part of what sort of implies to me that this is meant to be instructive of what we do as opposed to just FYI.
Do any of the commissioners have any comments or concerns about the language as it is presented on the screen currently?
Just note that in furtherance of that work was not in my original proposal.
That wasn't the question I asked. Go ahead, Commissioner Thomas.
I could just see ending that phrase at by program. I don't, I know we deleted the more specific information with cost broken out by type for each program. I don't know that that's really necessary there without the additional. Well, what do you mean by that?
Any other comments on the language or disclaimers? Hearing none, we will incorporate this language as presented in our motion and move on to the next item.
Before we leave this, I would.
Okay.
This is very minor. I went back and read our statement of basic purpose from last year with that part of that section. And that actually included a lot of the same language around more cost detail, more transparency, and everything else. So that's part of where I felt like requesting this additional information, being more specific about sort of that Smart Act type information was helpful. But all the other suggestions from parties, to me, were really already largely incorporated in what we did last year.
Right, and I really, that's one thing that I did notice is that they probably, I mean, Commissioner Slutsky kind of gave us a really good historic perspective on the SBAP and the purpose of the SBAP. But I also saw it, I think, being interpreted. I saw a lot of different interpretations, a lot of different things in this hearing. But I also saw that there were parties that interpret that as a directive to the division. And once again, I just want to reinforce that we're not in the chain of command of the division, and that the operations of the division is a responsibility of the administration. When we make suggestions or requests through the SBAP, that's essentially what they are, and that's up to the division to make that determination on how they proceed. But it isn't cast in stone as a rule. Thank you. So any other comments, concerns with this item as it is presented on the screen right now? Hearing none, we will proceed with that being part of the motion. Next item, please.
It's that last bullet.
Okay.
And just to reiterate, we would be rejecting, you would be, if you accept Commissioner Miller's proposal, rejecting all proposed edits to the language that is currently in Regulation 3 and adding that parenthetical.
Okay.
That's in quotation marks.
Commissioner Miller, when looking at this proposed language here, is it consistent with your intent?
Yes, thank you.
Thank you. Any comments, concerns by the other commissioners? Commissioner Rudolph, you have been.
Go ahead, Mark.
Yeah.
A couple things. I guess I really don't have a strong opinion on this. What I heard was that this was being eliminated because it really doesn't add anything substantive to the program, to the protections. You know, the increment consumption here is not something that's really adds much. By the same token, I think I also heard that there are not many sources where this is really comes into play, and I may be conflating that with something else. I can't remember, but I don't have. I'm fine with the division's original proposal to eliminate this in its entirety, but if there's commission desire to keep this in because of what I think is probably minimum additional protections, I'd be okay with that.
Commissioner Slutsky.
And this is redundant of federal regulation. So is that a worry?
So can you articulate what you mean by redundant?
I mean that the federal regulation has in it what we're asking them to strike from our SIP.
No, sir.
Okay, can you explain that a little?
Legally, my understanding is that this was a provision adopted by the commission years ago over and above federal requirements, inadvertently included in the SIP
What I get.
by EPA. The argument before you now, the division is saying it, given the changes in the NACs, has little benefit. Although the public commenter specifically asked you to retain it state only, which is what Commissioner Miller has proposed. But it is not a duplicate. It is not textually duplicative. This requirement does not exist. Whether or not you believe it is in practice duplicative, right, affords the same protections. That's a decision for you.
This is PSD.
Yes, PSD. My offer here is just legally that it is not textually duplicative. Right, this 75% increment consumption does not appear in federal PSD regulation.
Mr. Reader.
I'm somewhat like Commissioner Rudolph in terms of not having super strong feelings about this. I lean towards, I guess, supporting the division's proposal. And as I thought about it a little bit, it occurred to me that the General Assembly this year actually passed a new law on a bipartisan basis, urging all the regulatory bodies in the state to go through periodic review of their regulations and update things that are no longer applicable, helpful, et cetera. And I guess building off that action of the General Assembly, I look at this through that lens a little bit to say that the division has sort of made a determination that this is no longer particularly helpful, and that indeed these protections are achieved through other means. So I would tend to support the division's proposal.
Thank you, Commissioner Reader. Commissioner Milford, please.
Yeah, thank you. So I would speak in support of Commissioner Miller's recommendation to not rescind this provision. I do think that the division makes a good case that for the most part there's no effect here, but I think that it's hard to say what's going to come down the pike in terms of PSD applications, and they weren't really able to convince me that there wouldn't be a case where this could have a protective effect on the clean air in parts of the state where that clean air is highly valued. On the flip side, they didn't convince me that this was a significant burden on either the sources or the division. So I would support retaining XA5 as it currently exists, but just making sure it's only state only. as Commissioner Miller has proposed.
Thank you, Commissioner Milford. Couple thoughts of my own. I think anytime we take into consideration the public comment, I think that really reinforces the importance of the public comment, and hopefully it encourages the public to reach out to us. I think sometimes it's a pretty big reach for those individuals who do take the time to do that, realizing that we hear a lot. And sometimes it's really difficult to take into consideration those comments. So I think anytime that we can cite a situation when we do, that is a good thing. On the other hand, I think relying upon the experts that from the staff is also equally as important. So in a situation like this where there's a nominal impact, that's kind of where for me, I wanted to hear maybe a little bit more from the staff to kind of get a better rounded picture of what we're dealing here with. So I'm kind of on the fence here. Any other comments I think we'll go ahead and take a poll, but any other comments from any other commissioners? Commissioner Thomas.
Yeah, I agree with Commissioner Milford. I mean, I don't see this as a burden for the division. And while they expect that EPA will remove that provision from the SIP, they haven't done it yet, right? And I mean, this could easily be back on the table next year. I would rather see EPA's official action before considering removing this provision.
Thank you. Commissioner Sewell or Commissioner Davis, do you have anything you would like to share with us? Sure. One more chance, Commissioner Reader.
I just have Commissioner Miller has her hand up, but I a question for Commissioner Thomas. I wasn't sure because I'm curious where the division's current language, it basically says this becomes effective upon EPA's final action. If that is not sufficient for you, or why you want to see EPA's final action, I'm not sure I'm clear on that.
So this is for me, I think, because it's my opinion that you have to do it the way Commissioner Miller is proposing instead of just getting rid of the division sunset language. Is that?
Well, no, but I'm the way I heard Commissioner Thomas's comments, and perhaps I didn't understand them correctly. I personally am fine with the division sunset language. I think he was saying he didn't want to accept the sunset language. He wanted to see the EPA ruling before putting something into the rule. And I was trying to understand what he wanted to see from EPA or why that was important to him. If that makes sense.
It does. I mean, again, this is not really my area of expertise. This particular, PSD is not something I've traditionally worked in. So I'm okay with, I'm just supporting Commissioner Miller's amendment on this. That's what I'm saying.
Okay, I will go. Okay, Commissioner Miller, do you have something you'd like to add?
Yes, thank you. And thank you for acknowledging that this concern came not only from my own personal expertise on course PM, but also from the public comments. Many years ago, we were funded by the EPA to study the health effects of course PM in Colorado. So because I think at the time the EPA was looking at proposing an additional standard to PM course, which is different than PM10 and PM 2.5. It's the difference between PM 2.5 and PM10. In our results, we found very significant impacts of PM course on localized areas and also on health effects. However, the EPA never pursued this course of action due to other issues before them. So my concern is that if we end up removing something like this that the commission had put in previously to protect our state environment, and then we have an application from a source that creates coarse PM, it's not going to be taken care of by the NACs. And it's going to be a localized effect, meaning it's going to affect the local environment where these PSD considerations are really important. You know, nobody wants to see those pictures of Rocky Mountain that's hazy, for example. And we have so many other areas that we want to protect, but we also possibly could have sources want to create pollution there. So this is not just me saying I don't want this to be removed because of public action, but it's also because we have conducted research on this topic.
Thank you. At this time, I'll ask a show of hands. Who is in favor of including Commissioner Miller's proposed change in the motion?
This is to.
To include. Okay. It will be included with our motion. Okay. Thank you, Commissioner Miller. I think that gets to the end of the list, so I think we are actually ready for a motion with the amendments.
We have one prepared.
Okay, I suspected you did. Give staff just a few moments to complete the preparation of our motion. And I just want to say thanks to the commission for your understanding and support of me as I muddled through this hearing officer assignment.
Great job.
Yeah.
Excellent job.
Next time, just wear boots, okay?
I might need waiters.
For modeling purposes.
Yeah, I might need some waiters.
Muck boots.
Yeah.
Just finish. Just now.
Loading, and here we go. We're in. You can share that one. Leave it out. Yep.
Okay, we have a proposed final motion presented. I'll give the commission a moment to read that, and then I will ask for a motion. Okay, is there a motion on this action?
Do you need to read what's on the screen, or can we just refer to it? Legally, you don't have to read it out loud. Although it's fun to.
Okay.
We've done that with very long ones. And it's.
Yes, I know.
I will move that the commission adopt the regulations number 3 and number 7 pursuant to the language presented on the board, which includes the modifications A, B, and C, and then correcting the typographical errors, et cetera.
Very eloquently stated. Thank you. Is there a second?
Second.
We have a second. All those in favor signify by saying aye and or raise your hand.
Aye.
Aye. Opposed, same sign. Good. And that concludes the rulemaking hearing, and I will hand the gavel back to Commissioner Slutsky to proceed with the remainder of the meeting.
Well, thank you. And good work. Your first try at this. We didn't have any bad moments, did you?
Well, other than the disrespect shown by some, my immediate, you know.
So, we're good. We don't need any breaks or anything. We're gonna just muddle through, as we say.
Yeah.
So we're now gonna conclude with our briefings, discussions, and reports. And that would be item number 6 on our agenda, and that would be commissioner informational items. Commissioners are invited to discuss activities that they have participated in over the past month and any issues relevant to commission business. Did anyone have any fun this month? Past month? You guys are.
I did, but not on their quality issues.
I see Commissioner Milford had some fun.
I did, and I have some fun to recommend for the rest of you as well. The AQCC has issued their cumulative impacts report this month, and I think I hope Jeremy can share a link to that report with the rest of the commission, but it has a substantial chapter on air quality trends and cumulative impacts from the oil and gas sector, and lots of really good information provided by division staff. So I appreciate that contribution to that report and highly commend it to your reading.
Thank you. Anyone else? Well, then why don't we?
Don, I have, my big boss, Karen McGowan, got back from Mexico City last week, where they had a coalition of mostly very large cities internationally, and looking at this issue of local air pollution monitoring. And we've done a lot of work in the Love My Air Denver program around low-cost sensors, and you know it's really matured over the years. But she was impressed by the fact that the that Denver, of a city with 750,000 people, was really had really kind of taken this program to a pretty significant degree within our city. And so we're very interested in follow-up conversations around scaling and deployment. And so just wanted to give a shout out to our program there for punching up in their weight class.
Thank you, Greg.
Nice.
If there's no other participants for this item, we can move to the director's report. Michael?
Thank you. Before I get into the director's report, I just wanted to see if I could help answer any questions the commission may have with regard to permitting efficiencies. I wasn't on the witness list, and our program manager wasn't able to be here when we start our permitting program. But we do, I'm very intimately involved with a lot of the permitting work that's been going on We brief the governor's office on a weekly basis on our permitting metrics and numbers, and the governor in person on a monthly basis. So it's something where, we do have a lot of the metrics, and we are working very diligently with stakeholders to identify those permitting metrics or those permitting opportunities for improvement, specifically with industry. So we have regular meetings with them to identify which items would have the most impact. I know there was some discussion from industry about us not moving fast enough. I can tell you we had filed an important goal to actually improve permitting efficiency by 25% by June of 2026. When industry heard that, they actually went to the governor's office and asked them to slow down because some of the methodologies that we we're going to have to improve those metrics were something that the industry may not like in terms of the speed at which we're going to do it, what it could possibly do to permitting, generally speaking. So things like moving things out of the queue if they don't respond within a certain period of time, or standardizing permitting templates, which they may not like either. So all that's to say is while I hear industry has interest in moving faster, when we were at the point to move very, very, very quickly, they had a little bit of concerns, which I understand. And so just wanted to share that additional perspective. I know Commissioner Reeder asked about the use of AI. So we actually had two projects that we're moving forward with. One with a company called Caldera, who's going to be doing a search for regulatory opportunities for improvement in terms of efficiency using AI. And there's another one specifically in our permitting program with a company called Delta Bravo that's going to be looking specifically at how we can incorporate some of the smaller scale pilots with AI that we've shown 40% improvements with A/B testing, and now looking to do a little bit larger pilot with an actual tech firm to be able to pilot and build out some of those things, and hopefully being able to scale that with additional investment through a potential SIPA grant we'll be receiving in August of this month if it were awarded. So all this to say is, next time I'll just make sure I'm involved in not to be able to speak to a lot of this, but did want to share that additional information with you all to show we are very specifically doing as much as we can, as fast as we can, with industry kind of working together to find ways to improve efficiencies broadly. All right. The rest of my division directors updates on paper, so we'll read that. Planning and policy staff continue to engage with stakeholders and parties on ongoing efforts pertaining to oil and gas emissions controls, administrative rules, attainment of federal standards for particulate matter, and lawn and garden equipment use requirements. The division is now accepting annual air toxics reports for calendar year 2025. Reports are due by June 30th, 2026, and is working on tools to support implementation of the recently adopted emissions control regulations for priority toxic air contaminants. The technical report regarding rules and emissions control requirements for refineries was made available in English and Spanish on May 1st of 2026. The division will hold virtual meetings we did hold a virtual meeting on May 13th of 2026 to offer further information to the public. We also had a public meeting a few days after in person, which J.S. Hoffman spoke to during her testimony. Legislative update. So the session officially adjourned on May 13th, 2026, and we will have our legislative liaison, Carlin Gray. She'll be able to provide the commission a written summary as well as a legislative overview at an upcoming meeting. We did testify at the hearing for SB 26-101, which is the local government landfill methane emissions reduction regulations. We provided technical testimony to answer questions related to Reg 31. Following bills pertaining to air quality have already been signed or sent to the governor for a signature. That'd be the one concerning Clean Fleet Enterprise, replacing aging diesel trucks. Sunset Compliance Advisory Panel, Compliance Advisory Panel air pollution, which extends the statutory authorization for the Compliance Advisory Panel to the APCD by 10 years. Manage emissions from electric generating utilities, which requires coal-fired power plants directed to stay open by federal mandate to meet more stringent pollution standards. Local government landfill methane emissions reduction regulation. This bill makes regulation number 31, landfill methane projects, eligible for financial assistance. There's measures to reduce administrative burdens, which reduces administrative burdens by changing the mandatory review of the department rules by each principal department. The long bill, which funds the Colorado Department of Public Health and Environment as part of the broader $46.8 billion state budget, which was signed by the governor. And then lastly, an update to the Clean Energy Plan, municipally owned utility, which allows applicable municipally owned utilities to submit updated clean energy plans and extends their GHG emissions reduction deadlines. There's a handful of bills that have been postponed indefinitely: large load data centers, data center and utility modernization, ban government access historical location information database, challenges meeting 2030 emissions reduction goals, consumer regulated electric utilities, ban government purchase of personal data from third party, repeal retail delivery fees, and ban government access historical location information database. With regard to some of the tech modernizations, we continue to make progress to replace the antiquated and paper-based system and infrastructure. Key milestone was the full launch of the new permitting system for minor sources in March of 2026. The updated platform facilitates the electronic submissions of construction and general permit applications while providing more robust reporting and data transparency, permit tracking, improved permitting process efficiencies, and reducing incomplete and inaccurate application submissions. The major source or Title V permitting system is also being replaced. The division's technology and permitting staff are working with the contractor on the development of the system, which is scheduled to be completed by June 30th of 2026. The current focus is on user acceptance testing and associated refinements of any identified issues that will facilitate a stronger and more efficient system and user experience. After the system is complete, priority steps include training and system documentation to support both internal and external users. While the most significant focus has been on the permitting systems, additional systems are also being developed for replacement, including indoor air lead and asbestos system. While the most significant focus has been on permitting systems, additional systems will also be developed for replacement. Lastly, the contract to replace the oil and gas reporting system on here has been finalized and development work recently began. The project is expected to be completed in early 2027. The General Assembly and Governor closed the $1.5 billion budget shortfall and adopted the fiscal year 27 budget for the state. The electric school bus grant program balance was swept to support budget balancing needs. The division's technology modernization project received an additional appropriation of $1.7 million to support ongoing replacement and development of core systems. The division continues to work on new greenhouse gas reporting systems so regulated operations can comply with Regulation 22 reporting requirements in light of the EPA's platform not being available for most reporters. Reporting is anticipated to be available in the summer. The climate change program held a kickoff meeting for members of the remote methane monitoring working group for AQCC Reg 31 landfill methane rule on May 18, 2026, and will be scheduling monthly working group meetings that the public can listen to starting in June of 2026. The ASVAB for Regulation 31 directs the division to convene a remote methane monitoring work group to develop guidelines for the implementation of the remote methane monitoring requirements of Regulation 31. The climate change program issued almost 300,000 credits to 2 GEM 1 facilities and 7 GEM 2 facilities during the first week of May, which represents an increase of 70% credits issued compared to last year, which was the first year of credit issuance to the GEM facilities under Reg 27. GEM 2 facilities specifically increased their credits by 40% from last year. This year was the first year GEM 1 facility credits were issued. The upcoming annual auction will begin in June of 2026. Also during April, there was one new bilateral transfer of 33,807 credits from Microchip Technologies to Rocky Mountain Steel. The division continues to prepare for the Reg 27 rulemaking in July. Most recently, the division submitted its response to comments. The division continues to engage with parties and will be submitting its position statement by June 4th. Finally, final 2030 GHG reduction plans for GEM 2 facilities are now publicly available on the GEM 2 website. Registration is open for the series of public meetings in June, where the division will review the analysis process and resulting facility plans. The prognostic meteorological data access tool has been posted to update air quality modeling page. This data and tool is intended to be used for research and evaluation purposes. The division is evaluating the applicability of this data for its use in permit application max analysis. Upcoming public meetings that we host, the Colorado Refinery Report meeting. This meeting will summarize the findings from the refinery expert review under House Bill 24-1338. And then we have lawn and garden in-use requirements, Reg 29 meeting. The division is continuing to do outreach about the proposal to expand lawn and garden equipment requirements to commercial operators, and there will be a public meeting on May 27th and more this summer. That concludes my Commission Director's report. Happy to answer any questions if anyone has any.
Commissioners, questions?
Just really more of a comment. First, I want to say thank you for the little commentary about AI and some of the stuff that you had before your report. I was also really interested to see the data on the GEM trading was really helpful. So I appreciate you sharing that. And then under the bills, I was aware of many of those bills, but I was not aware of the one about the landfill methane and making financial assistance available. I know that was something that I think Commissioner Rudolph and I both kind of spoke about during that regulation. It'd be nice if there was some grant money available to help some of those local governments, and it's nice to see the General Assembly enable that or make that happen. So I just thought that was really worth noting. So I thought it was a good thing. So thank you for the report.
Agreed.
Jana.
Michael, thank you for your report. Yesterday, when Mike Silverstein presented the update on the blueprint from the RAC, he indicated that they are looking at, I guess, some funding shortfalls and needs to secure other funding to continue that effort. I wondered if you have any insight for us on how that affects the division's work on moving forward with ozone planning.
I don't think it has a significant impact in terms of our ability to continue to work with the RAC on the ozone planning. The funding shortfall that, my understanding of the funding shortfall that they're discussing would be around the funding request from the Air Quality Enterprise Board to build out the strategies around the blueprint. So it doesn't change my understanding is that it doesn't change their ability in our, continued partnership in ozone planning.
Thank you.
Yeah, I would just add to Jana that there were a lot of projects funded. I mean, there were like 43, I think, that were submitted. And I think 34, 35 of them got funded. So there's a lot in there about ozone research and precursors and this. And so I don't think that us in the state, I think we're going to be learning a lot more about all of this over the next few years.
Shelley?
Yeah, thanks for that update, Michael. I was wondering if you could share just a little bit more about the more stringent pollution standards that will be mandated for required coal fire power plant openings. That's the HB 26 bill, 1226.
I don't have any additional details at this moment. However, we could have Carlin provide some more specific detailed updates on all of these bills. Hopefully at the commission retreat, I know she will be in attendance.
Yeah, that would be great. I'm interested. I mean, I opened the bill, but I haven't had a chance to look. So I just wanted to know what you thought. But I was like, is it more mercury? Is it better PM 2.5? Is it more SO2? So I'm just interested in any ideas there. Thanks.
Michael, can you talk about the future in the legislature? I just wonder, you know, what's coming down the pike, if anything, and will they, probably you don't know, with any new legislation or mandates for us, would that come with money attached to it?
I don't know if I could speak to the future of the legislature and certainly not with money attached. However, I can tell you that, you know, we haven't had oil and gas regulations for the past 3 sessions due to an agreement between state and the legislature. So what I would anticipate is more oil and gas regulations in future legislative sessions.
Anyone else? Thank you,
I'll
Michael.
quickly note that we do have a presentation that forthcoming at the retreat as well.
Just one other comment, and it's spurred by Michael's report, but it's not directly related to the report. But Commissioner Thomas's comments about all the things that are being funded by the Air Quality Enterprise. I would suggest that maybe we should get a briefing from Jeremy Newstifter or someone at some point on an upcoming meeting when we have space for that.
We are planning that actively.
Okay, cool. Okay, thank you.
Thanks.
Thank you, Michael.
Thank you.
We will move to our Attorney General's report, Robin and Corey.
In order to balance the speaking time, Robin and I decided I would deliver the report this month, so I have approximately an hour and a half to go. So
I moved to censor.
Appropriately, I have 3 matters I wanted to update you on today. There's a lot of work that we're doing over as your attorneys here and the ones you don't see in the room today. But the first relates appropriately enough to a permitting challenge. Underscoring the importance of the work the division does and the permitting teams do and the scrutiny that they face. So how important it is that we talk about inefficiencies and how much time is spent. Well, there's a reason for that. So the division was sued by the Center for Biological Diversity over 2 permits that were issued by the division to oil and gas production facilities in Adams County. The permits contain several federally enforceable conditions imposing limitations on emissions from the sources, but the center argued that the division improperly labeled certain monitoring, record keeping, and reporting requirements intended to verify those emissions limitations were being met as state-only enforceable as opposed to federally enforceable. Oral argument was held on April 3rd and in record time, just over a month. We got an order from the court there at Adams County endorsing the division's arguments, lock, stock, and barrel. It represents great work from your attorneys on that team.
Which include Corey.
I mean,
Yeah.
he's not here, but it was a fun fact. It was the first oral argument for the other attorney on the team. Ben Elbrock did a really good job representing the division in this report, and that he's on vacation in Portugal. So, yeah, that's it. It was a good outcome for the division, and it really just justified our reading of your regulations. Second matter I wanted to update you on is the new lawsuit filed against the division. The work continues. Job Security's attorneys. On May 8th, the National Waste and Recycling Association filed a complaint against the division for its issuance of a revised permitting section memo interpreting and applying your landfill regulations, clarifying the division's use of emissions calculations for landfills. NWRA alleges the division's memo as a legislative rule that did not comply with the APA. Case is very early in proceedings, complaints been filed, and that's all it is. So more to come on that one in the future. The third,
Tell me who the lawyer is representing them.
it's currently it's Shin Beaver and Carlos Romo at Williams. Yeah, Jen was not here this month. Maybe she's busy. I don't know. And the third item we wanted to update you on is the status of the challenge to the Department of Energy's emergency orders relating to the Craig unit, generating unit number 1. The Department of Energy denied our petition for reconsideration of the first emergency order regarding the reopening of Craig 1, and we filed a lawsuit challenging that decision in the DC Circuit Court of Appeals. Another one that's very early on. Our suit has been consolidated with separate challenges to that decision brought by public interest organizations and the operators of Craig Unit 1, Tri-State and Flat River Power Authority, I think is the other. No briefing scheduled yet, no deadlines, but that's the beginning. And the interim department issued a second emergency order regarding Craig Unit 1. And then, Groundhog Day, we filed a petition for reconsideration of that. We anticipate that to be denied, and then a new lawsuit to be filed related to that in the near future. I'd also note that we're following another similar challenge in the DC Circuit relating to emergency orders issued for our coal plant in Michigan. I think that one's on its 5th emergency order because of, it's kind of everyone's stepping through the same process. We had oral argument in that case last Friday. So we might get an indication from the Court of Appeals there on how these challenges are going to go in the near-ish future.
What's the basis for the challenge for our challenging on Craig? What are we saying is the issue here?
I'm going to defer to the attorney who's on the brief next to me.
There's a lot of arguments that Colorado makes in the brief, and I do want to flag that lead counsel is the Energy Office attorneys. So Gabby Falcon and Jessica Lowry from my office. And they've been doing a great job, but I think largely it's energy emergent, this is not an emergency either under the facts or the law. Even if there is an emergency, keeping Craig Unit 1 open doesn't address the emergency identified. And things of that nature, I'm happy to send. It's a good read.
I assumed it was based upon energy. I mean,
yes, and
lack of an emergency.
So I'm having a nerd out on this because I find it so interesting. But the way that 202C works is they say basically what it does is it excuses the operators from non-compliance with environmental regulations and permits if there's an emergency, right? And so your air division and your air attorneys have been involved assessing what are the potential violations and what are the potential air quality impacts of keeping this coal unit online. I do believe it has been, in the first 90 days, it was not called on, but in the second 90 days, it was called on to get ready, but I don't believe it was called on for power. And so, that, I think in our view, in the state's view, there's no emergency that is addressed by the continued operation of Craig Unit 1. And I'll just say that, and that leads to a bunch of different legal arguments that we can make. There's also, I thought the Energy Office team did a nice job making the argument that it's a pretextual, right? And these are energy orders given the breadth and scope of how they're being used are really just in service of what we've heard from the administration, that there will be no coal plant that closes on this administration's watch. Yeah, so
I presume also that there were the consequences of requiring it to stay open from an air quality and public health. I presume it was just everything was put in all the arguments that we would have.
All the I'll give a big commendation to Josh Korth and the inspector for the Craig plant, Chris Reiner of the division, who have spent innumerable amounts of time in the permits and in the inspection records, helping us understand what those potential impacts could be, so we could, correctly advise the court, right, on those impacts. I also would note that this this order, I think, is unusual than most of the ones that would issue because it was challenged by the plant operators themselves as well. Because of the cost and they're concerned about whether and how they can pass those costs on to ratepayers and in fact, if they can. So that is still also a very live issue. Like if the federal government issues these orders, who has to pay? Is it the federal government? Is it the utilities? Is it the ratepayers?
I have a follow-up question. This has been a very interesting issue that is evolved, and as I understand it, and if I'm wrong on this, please correct me. But there's been concern about Excel having enough generating capacity this summer. And Excel said, well, PUC will get you a plan like by July 31st about that.
It should be submitted.
PUC, I think, asked for it April 15th, and it was submitted. And Excel, as I understood from what I read just in the press, talked about getting power from Craig One to bridge this summer shortfall. So I'm curious how that.
So I'm not up to speed on all of the actions that Excel is proposing at the PUC. I'm not gonna make her come up here, but Amelia and Julie represent Excel, and I know that they are, and Jill Van Dorn from Excel was here yesterday. And I'm, terrified of misspeaking, but there's a lot going on at the PUC to address concerns that Excel has raised about its capacity both this summer and next summer. I think the next big filing we expect to see is June 15th. It was going to be due June 1st, and that is really about Comanche. Comanche Unit 2 and Comanche Unit 3 and what Excel might need to do with respect to those facilities. And I do believe there's a lot of people smarter than me working on how do we make sure that everybody gets AC this summer, and such thing in a way that minimizes costs to ratepayers and environmental impacts.
And perhaps I misunderstood from what I read about that April 15th filing. To me, it was just.
There's been a number of proceedings that the company has initiated. It's, as I understand it, this is just, sort of general, is that typically liability planning is a long process and companies propose a plan and 2 years later the PUC acts and everybody gets time to be thoughtful. But because of various things that have been going on in the past year and a half to a little bit more, there's been a lot more of a like, oh my God, and the PUC, we need this and we need it now. Type filings, and so I'm just not up to speed on all of them that have.
Thank you.
Now I have another transparency. Continuing the theme of retreat planning, just would put a plug in, if there's any issues that we already have developed an agenda for our portion of the retreat, but if there are issues that you're particularly interested in hearing about from us, please do let us know and we'll try to incorporate that. Thank you.
And finally, our administrators report.
Right, thank you, Commissioners. I will try to be brief here to get us done with this meeting. Appreciate all your hard work this month, getting ready for this hearing. I'm quickly going to go over our agenda for the retreat next month. We have a lot of our details now in place, thanks to Jenny's hard work. Wednesday, we'll plan to meet around lunchtime on June 24th down in Buffalo. We're going to be in the downtown area for the entirety of the retreat. Hopefully, we'll have lots of opportunities for walking around and enjoying the river walk and walking to and from our hotel and conference center and our public comment session. So we'll have an executive session with your annual legal training. And Corey and Robin will handle that. They have a list of topics.
Corey just won himself the right to do it himself.
Okay.
Yeah.
We'll be having all
Deserve that.
Like Corey said, if you have any topics that you're particularly interested in hearing more about, just get those over to us and we'll do our best to incorporate those. That Wednesday evening at 4:30, we will walk or drive over to the Buffalo Heritage Museum for a public comment session and hear from the public. We've got lots of outreach ongoing already to the public down there, so hopefully we'll have a good turnout. And then Thursday, we will have our more typical retreat agenda going. We'll have a number of briefings on some various topics. We'll have a briefing on your favorite topic, permitting and the backlog. Then we'll talk a little bit about procedural rules and how that's going for you all as commissioners. And we'll also probably talk briefly about how we want to hear from our frequent flyers in upcoming meetings. I'm thinking the August agenda right now is pretty light. So we could have some time set aside in August to maybe an hour or two for a work session. We could have folks come up and just tell you how it's going. I think there's interest from the stakeholders I've talked with to do that. And you all can ask questions as well. Then we'll have a presentation on power plants and data centers. And then I will give you a pretty quick legislative update on bills that were passed by the legislature. Then we'll get into our updates from the Air Division. Lots of folks from the Air Division will be attending the retreat and give you some quick updates on what their programs are doing. Then in the afternoon, we'll have our election of officers, our chair, vice chair, and secretary. Then we'll go over our normal action items, the review of the minutes, that sort of thing, talk about the July agenda. And then we will do some long-term planning of our calendar for 2027. And then that will wrap us up for Thursday. And then Friday, June 26th, we have a tour scheduled in the morning at the AQCC Pueblo cement plant, which is one of our gym facilities. So that'll be a great tour. Still working out details on timing and what that's going to look like with the staff there, but they've been very accommodating. And then I quickly wanted to mention it. Let me stop there. Are there any questions about the retreat?
Yeah, as a new commissioner, what's the dress code?
You can,
Pajamas.
yeah, but it's pretty
Very close. You don't want to see it.
You don't want to see that.
If you see anyone wearing a sport coat, they're overdressed.
Dress.
You'll see commissioners in shorts,
Yes.
so.
That's Pueblo. It's gonna be.
That'd be curious on this as well.
I think for the public comment, you might want to dress a bit more professionally in your capacity.
Nice shorts.
Yeah, at least from the waist up.
Your shorts have a 4-pocket max.
Or pockets.
So we'll do that on Wednesday evening, and then Thursday will be much more relaxed. We're going to be in a small conference center. It's not going to be live streamed or anything, so feel free to dress comfortably.
None of this is virtual.
That's correct. None of it's virtual. Even the public comment is in person only. It's all real. Okay, so moving on very quickly to another topic that I've heard from a couple of commissioners on. There is a ozone conference going on in October, the end of October, being put on by some of the Intermountain West MPOs. And I know there's interest from the organizers and commissioners attending that event. And I know some of the commissioners are interested in attending. I don't know what the cost of that conference is going to be yet. It hasn't been announced. But we're working with the organizers, kind of understand how they would want you all to be involved and what that looks like. And you'll be getting some more information from me and probably the attorneys as well on how they interact at that conference if you do attend. So just stay tuned on that. Right, any questions on that? Hearing none, those are all of my updates. Thank you.
All right, Jeremy, I have one small question. It just came to me. It's about the retreat.
Yes, of course.
I had been working a couple of years ago with a grassroots environmental justice group called Clean Air Pueblo. And it looks like they're still continuing to do some enhanced monitoring in Pueblo. For example, putting out purple airs in the community. Anyway, I wanted to make sure that they knew we were going to be there, and maybe they would and those kinds of organizations would be able to participate in the open comment or in the meeting that we're having.
Jenny, do you know if we've reached out to them?
Yeah, the eco team reached out to them,
So,
regarding our public comment session.
okay, I'm not sure if you can hear, but we have been working with our eco team, which is part of the air division, to get the word out, and they have spoken with.
Great, thanks.
Right on, that's back to you.
Last call for questions. Then meeting is adjourned. It is 11 a.m. Cool.
Yeah.
Damn Pueblo.
You can hang around if you want. I gotta sit around and talk for a while.
Yeah.
Thanks.
Yeah.